Hi, welcome to the 2015 HIPAA and Compliance Training. My name is Samaria Dunson, and I'm the Director of the Office of Compliance and Ethics here at the Alabama Department of Public Health. I also serve as the agency's privacy officer. This web-based training video will teach you the basic precautions to take to assist the department in satisfying federal regulations. Our HIPAA privacy and security procedures are detailed in the 2015 HIPAA Privacy and Security Policy. All staff authorized to access PHI and ePHI must understand and follow these procedures. A copy of the 2015 HIPAA Compliance Policy can be found in the Policy Library and at adph.org/compliance education. It is important to note that some of the documents in the compliance policy are provided to us by other bureaus. For instance, the Office of General Counsel has provided us with a memo on how to handle legal documents. Questions about that memo should be addressed to the Office of General Counsel. In addition to that, there are references in the compliance policy to the employee handbook and the professional conduct policy. Any questions related to the employee handbook and the professional conduct policy should be directed to the Office of Human Resources. Should you have any questions or want to share concerns related to compliance, you will be provided the contact information for the Department's Office of Compliance and Ethics at the conclusion of this training. Please understand that this 2015 HIPAA training is a refresher course. You are required to have viewed the HIPAA Privacy and Security Awareness Training before participating in this 2015 refresher training. Understanding that your time and attention are valuable, this HIPAA refresher training is a joint training which includes training on the ADPH compliance policy. In order to receive credit for this training, you must do two things. The first is to watch this video in its entirety. So what does that mean? That means that you need to be watching and focused on this video the entire time that it plays. Don't just press play and run to the bathroom, press play, pick up the phone and start your work. This is something that you really need to be paying attention to. The second thing that you need to do is to make sure that you complete the acknowledgement form that's associated with this training. When you complete the acknowledgement form, you are acknowledging that you have read the 2015 HIPAA Privacy and Security Policy, that you've reviewed the 2015 Compliance Policy, that you have read and reviewed the Professional Conduct Policy, and also that you've reviewed the Remote Access Policy. Many of you all will remember that the Remote Access Policy was a document that you reviewed last year for the 2014 training, and everyone has looked at the Professional Conduct Policy upon hire. So you'll be acknowledging all of those things in your electronic acknowledgement. Topics that we'll be discussing today include patient rights, disclosures of patient and client information, methods of communicating protected health information, or PHI, minimizing the introduction of malicious computer software, the proper use of passwords and/or system usernames, the proper disposal of PHI, reporting privacy and security breaches, sanctions for violations, the False Claims Act, the Anti-Kickback Statute, medical record coding, the excluded, suspended, and/or disbarred individuals or entities, and conflict of interest. Some of the privacy objectives will include a basic refresher of the HIPAA privacy rule, how to handle patient or client PHI both in paper and electronic form, reporting breaches of PHI, and understanding the consequences of not following HIPAA regulations. Some of the security objectives include securing electronic protected health information, or ePHI, at rest while in ADPH custody, securing ePHI in transit, and protecting against reasonably anticipated threats to ePHI and unauthorized access and use. Now, as a part of our general compliance, those objectives include understanding the False Claim Act and the Anti-Kickback Statute, and when and where to report violations. So I want to go ahead and get started. Now, I know that because this is a refresher training, that many of you all, like I said, have already looked at the awareness training, so I won't focus very, very heavily on a lot of the things that we already focused on in the awareness training, but I do want to remind you of some things. So PHI is any identifiable health information about an individual's past, present, or future medical or mental condition that's transmitted or maintained in any form by a covered entity, like the Department of Public Health. So you've seen this slide before. You already know that it includes names, address, and date of birth. I want to remind you all, though, that within a health record, a person's telephone number and their email address are also considered to be PHI. Additionally, if it's a full-face photo of an individual, that's considered to be PHI. And I also want to remind you that the medical information that's found in our employment records are not considered to be PHI, simply because our employees are not considered to be patients or clients of the department. So as it relates to HIPAA, employment information or employment records are also excluded. Now, HIPAA is not intended to interfere with an individual's access to health care or the payment for health care. So the privacy rule permits a covered entity to use and disclose PHI for treatment, payment, and healthcare operations activities. Now, you'll see this from time to time as HIPAA exceptions of TPO, or treatment, payment, and healthcare operations. So, for instance, if a doctor's office contacts one of our county health departments and they have the same patient and they're looking for some information from our record about that patient, we can freely share that information with that physician in order to treat that patient. Also, if our employees are having conversations with Medicaid or Blue Cross Blue Shield in an effort to pay for someone's health care, that's also considered an exception. You don't have to have patient authorization to share that information. Now, one thing that I do know from talking with people in the counties, in the tower, and at the lab, I wanted to find out how people learn the best, because I wanted to make sure that this refresher training was something that really benefited our staff. And what they let me know is that people really enjoyed the skits. So I can tell you that throughout the course of this training, we have a number of skits. I personally think that they're pretty funny. I certainly enjoyed them and enjoyed working with the actors. And so now I'd like to move to the first skit.
Oh, yes, ma'am. Good morning. Would you please sign in?
I'm just here to get a copy of my medical record.
Oh, well, sure. That'll be just fine. I just need you to sign this form.
You must not understand. I am not here to fill out paperwork. I'm here to get a copy of my medical record.
Oh, now, yes, ma'am. We're going to accommodate you, but...
I know my rights, and I'm not moving from this spot until you give me a copy of my medical record. Do you understand now?
Okay, so this happens all too often where we have patients coming in, they're being demanding, they know what their rights are, they're throwing HIPAA around. So that gives us an opportunity to talk specifically about what patients' rights actually are. First, they have a right to obtain a copy of the Notice of Privacy Practices. The most current version of the Notice of Privacy Practices can be found on our website at adph.org/compliance. We want to make sure that the 2013 is the latest version that we have. That was when the federal regulations changed. So that's going to be the most recent. We want to make sure that we have that available. Also, they have a right to copies of their records, to view their records. They have a right to amend their record if they can prove that the information that we have is inaccurate. And I just want to remind you, because I know I gave this example a few years back, is that just because they don't agree with the terminology that we use, it does not mean that we'll change the record. They have to actually show that the record itself is inaccurate in order for us to make the change. They have a right to limit the uses and disclosures of their PHI. They also have a right to an accounting of their non-routine disclosures of PHI. And I know for all of our employees who are trained as it relates to the HIPAA log, they understand this particular requirement of an accounting of their non-disclosures. But for those who have not had that training, let me just tell you briefly that our patients, just as you would at your normal physician's office, they have a right to know where their records are being disclosed to. And if you notice, it says non-routine disclosures. And that's because information that's a part of that treatment, payment, healthcare operation that we talked about earlier, those are considered routine disclosures. So if I go to my doctor's office and they've sent information to my eye doctor or my foot doctor, they don't keep an accounting of those. Those are routine disclosures. However, if they release my records because of a subpoena, or if they release my records to DHR, or for some other non-routine disclosure, they are to keep an accounting of that, and I have a right to know where my records were sent. Patients also have the right to authorize the department to provide their information to someone else. This happens a lot by using the CHR-6. I know a lot of our employees are familiar with that form. So they can say, hey, I want you to give this information to my attorney's office. I want to you to give this information to my family members. And finally, they have a right to request confidential communications. So an example of when this may happen is, let's say you have a married couple. The wife may be coming in for STD treatment. She doesn't want you to mail letters to her home. She's afraid that her husband might see it. She says, hey, if you want to contact me, please contact me at this cellular number. Or don't call me at home, only call me on my cell phone. To the extent that we can, we will try to make sure that we grant those requests for confidential communications. They have a right to make a complaint to the Department Privacy Officer, which would be me, or to the Secretary of the Department of Health and Human Services if they feel that their rights have been violated. I want to make sure that all of our employees understand these are two different offices. The Privacy Officer is for the Department of Public Health. The Department of Health and Human Services is a federal agency that is basically what I would refer to as the HIPAA police. I always would prefer to know that a patient has a concern directly from that patient or from one of our employees. The first time I hear about something, I don't want it to be coming down from the feds. So if you have an issue, a privacy or a security issue that you're addressing in one of our offices or one of our counties or areas, please make me aware of it. I prefer to know that there's an issue from you first so that I can begin to start addressing it. Now, there are some exceptions to these uses and disclosures of PHI. Patients cannot get information related to their psychotherapy notes. They cannot have access to that. Usually in our department, these are seen as social worker notes, things related to their psychiatric analysis, or I'm sorry, I'm not a medical provider, but I do know that they cannot have access to those psychotherapy notes. Now, if there is any issues with that, please contact me and we can talk our way through any of those issues. There are times when we might deny someone access to their PHI. They're few and far between. One of those times would be if a licensed healthcare professional determines that access may endanger the life or physical safety of an individual. And these scenarios are possible. They have played themselves out before. Additionally, like we talked about with the psychotherapy notes, that none of that would be given to the patient. And these denials have to be documented as a progress note in their chart and also placed on the HIPAA log. But to the extent possible, we do try to give patients access to their records. So what we might do is if we're looking at their entire file and there's information that they cannot have within that file, what we will look to do is redact the information that they can't have and provide them with all of the rest of the information. But in each of those circumstances, I need to be contacted so that I can be a part of that conversation. Let's go to the next skit.
Good morning. Welcome to Public Health.
Hi.
Please sign in and somebody will be with you in just a moment.
I know her. She dates my 16-year-old son. Why is she here?
I think she's here for family planning, but I'm not sure.
Family planning? I don't work in family planning, and she is not my patient, but I need to know what this is about. Give me that file.
I don't want to be a part of that. I don't think you're supposed to see this information unless you have a need to know.
Let me tell you one thing. I have a 16-year-old son, and in my world, that constitutes a need to know. Now, give me that file. Pregnancy test. Got to call my husband. Are you sitting down? You will not believe this. Or maybe you will.
Okay, so this is a skit that we've used before. I think it's a classic case. I know that a number of the people in our counties, especially the smaller counties, will understand how this situation plays out. Again, this is in no way picking on WIC employees, but she does wear the WIC badge, which shows that she probably should not be having access to family planning records. She's saying, I have a need to know. I think that we need to all make sure that we understand that this is a work-related need to know, not a personal need to know. I actually feel like I need to know when Beyonce is having her next baby. I really feel personally like I need to know that. But this is not a personal need to know. This is a work-related need to know. Also, I want to discuss the fact that at the conclusion of this skit, she's calling her husband to share that information with him, which is obviously going to create a breach. But this also gives us an opportunity to talk about minimum necessary, because this skit certainly violates the minimum necessary rule. So what is the minimum necessary rule? It is a violation of the minimum necessary rule for a healthcare provider to access the PHI of patients with whom the provider has no treatment relationship unless it's for research purposes. The minimum necessary rule does not apply in just a few cases, so there are some exceptions. If there is a healthcare provider that's asking for information, we as a department, if they say that they need the full medical record, we will give them the full medical record. We don't question other healthcare providers as it relates to how much of the information that they actually need. So that's one exception. Another exception is when the patient is asking for information, their own information, or a legal representative. So with the exception of those psychotherapy notes, we would give them a copy of their entire record. Also, pursuant to an authorization, information pursuant to an authorization. So if they say, hey, I want my lawyer to have all their information, and they fill out the CHR 6, we will provide them with the entire medical record. Also, disclosures that are made to the Department of Health and Human Services, we're going to give them everything that they need. And let me take this opportunity to explain something about the Department of Health and Human Services, because you're going to hear that from time to time. These are the HIPAA police, as I mentioned. They are the ultimate authority as it relates to anything HIPAA. If you get anything in the mail from the Department of Health and Human Services, Office of Civil Rights, or any emails from them, I want to know almost in real time that you got this communication, because a lot of times if they're requesting information because they're doing an investigation, there are time restraints related to those requests. And so I need to know about that. I need to know about that as soon as possible if there are any communications to you from the Department of Health and Human Services, so they can receive any of the health information that we have whenever they're doing an investigation. Other exceptions would include uses and disclosures that are required by law. And then finally, any compliance with HIPAA standardized transactions. Those would be exceptions to the minimum necessary rule. Now, as it relates to staff access, even those employees who have a work-related need to know the information still have to use the minimum necessary when viewing a disclosure of viewing and disclosing PHI. So, for instance, in the skit that we just watched, if Bill, the gentleman that was standing there in the skit, if he needs to go back in a patient record to get a date of birth or to get a social security number, he needs to be going back in the record looking for those things. If he's not treating the patient right then, he doesn't need to be looking at STD or family planning or anything else related to their record. Another important thing I wanted to share with you has to do on this slide with the volunteers and the students and how their permission to view PHI must be documented. I want to remind everyone that I know it was in the 2013 policy and the 2014 policy. There's a document in that policy. It's one of the first forms at the end of that policy. If you have a volunteer or a student and they're about to get access to PHI, you need to fill that document out. Say, hey, my volunteer is Samaria Dunson. She can start looking at PHI on September the 14th, and she's going to stop volunteering for us on October 14th, and therefore she no longer has permission to view PHI after that date. Now, for all of our volunteers and our interns or students, they have to go into LCMS and view that HIPAA training that's there for them. It is a merged training. It is a shorter training. We try to do the best that we could in order not to just completely inconvenience them, but we wanted to make sure that they had enough information so that they know how to handle themselves as it relates to HIPAA while they're volunteering or interning at the department. So as it relates to volunteers and interns, the first thing they have to do is look at the HIPAA video and do the electronic acknowledgement for that. And then also on the local levels, whether it be in the office, the bureau, county health departments, they need to be keeping that form documenting when they can start looking at PHI and when their access to PHI is terminated. So now we're going to go to the next skit.
Looks like the waiting room's getting filled up. You announced we're doing family planning visits so we can really pack it out. Hey, did you have a chance to watch TV last night? There was a show on there called America's Got No Talent.
Oh, I love that show. It's so funny. Uh-oh. You got a fax. Better you than me.
Jessica Smith needs her records sent over to Dr. Walker's office. Looks like all they really need is her STD test results.
That's so loud. You don't want everybody in here to hear you.
Hey, I'm just a loud person. It's who I am. I can't help it if my voice carries. I don't have time to go through this whole thing and find her test results. I'm just going to send over everything I got. It can't hurt. 1 3 3 4 5 5 5 5 2 3 6. Send. There she goes.
Hey, that's got PHI on it. It doesn't go in the recycle bin, does it? It needs to go in the shredder.
It's all the same thing.
No, it's not.
Okay, so I don't even know where to begin necessarily on this slide. There's so many things wrong. I mean, there's so many things wrong with that skit. The first thing has to do with the tone of voice. Now, I know people, I have people in my personal life. I work with people who say, hey, I just have a loud voice or my voice just carries. And that's fine if you're at home or you're at Walmart or at a parade. But if you're going to work in the healthcare field and you're going to work for the Department of Public Health, then you need to make sure that you're keeping your tone low enough that you're able to keep our patients' information confidential. You don't need to be behind the reception desk and the entire lobby hears everything that you're saying about patients. And there are no exceptions to that requirement. The second thing I wanted to talk about were the fax procedures. I know that we're all aware that when we get ready to send a fax that we need to let the person, and there's PHI in that fax, we need to let the recipient know that it's coming so that they're available to receive it. And then we also need to make sure that we keep the confirmation to make sure that the fax actually went through. And in this situation, as you could see, she just walked over to the fax machine, sent it through, and then just left the documentation on the fax machine. In my walkthrough activities, I have found that for the most part, the department and staff are utilizing that fax procedure. For those who aren't, just understand that we are really tightening up on that. And I want to make sure that we continue to do better and better as it relates to following those fax procedures. Also, the minimum necessary requirement, she just completely disregarded that. When the physician sent over the request, they requested specific test results. Well, because she didn't feel like it or didn't have time to go through the record and give them exactly what they requested, she just sent the entire record over. That is a violation of the minimum necessary rule, and you cannot do that. She has to send them what they requested. And then finally, an issue that I saw has to do with the disposal of PHI. So I know all of us know we have trash can, we have a recycle bin, and we have a shred bin. And many of us, for our shred bins, are big shred bins that are locked in our offices or our bureaus or our counties or our areas. So the trash, I'm not going to get into everything that you want to put in the trash. Your snacks, your lunch, whatever you want to put in the trash is fine as long as it's not PHI. As for the recycle bin, whatever paper you want to put in there, magazines, drafts of documents without PHI on it, depending on what your supervisor says about the confidentiality of those documents, you all can make a decision about what documents go in your recycle bin. But any information that has PHI on it, anything about patient's health information needs to go in the shred bin. That is very important. We have business associate agreements with Lambert and Gilmore and the other shredding companies that we use. So it's very important that we put all documents containing protected health information in those shred bins. Now let's go to the next skit.
Finally, I've uploaded all that patient data.
Oh, good. It's time for lunch.
Let me hit send, and I'm done. Hello? What? I did what? You have got to be kidding me. This is terrible. You guys, I just sent all that patient data to the wrong group. Oh my gosh.
Well, look, we're hungry, so let's just go eat, and we'll help you call the compliance office when we get back.
Okay.
Okay.
Okay, so I could actually like just pass out and die. You absolutely cannot do that. Let me begin by talking about email encryption. So we do have email encryption. We've had it for almost a year now. So, and I want to thank our IT staff for providing us with that and monitoring that. It's going to automatically try to pick up things that are in your email. So if it sees social security numbers or dates of birth associated with some type of health condition, in addition to other criteria, it's going to encrypt those messages for you. But if you send it to the wrong person, it'll get to that recipient in a secure fashion, but it's still the wrong individual. So the first thing that you want to do is contact me so that we can begin addressing that issue. The main thing I want to focus on is mitigation. We've had these instances happen, and this accident, and we understand that when people are working with health care information constantly, or PHI on a regular basis, there are going to be some things that happen. The most important thing that you can do for yourself and for the department is to notify me as soon as possible. What I'm going to do is, depending on the size of this potential breach, is go ahead and begin helping you make phone calls. So, for example, in this particular incident, if she sent that to 20 people, I'm going to get that list with her, and I may get my assistant, or I may try to get some individuals in legal to help out, or other divisions, to start calling those people before they have an opportunity to open the email and say, hey, Ms. Smith, you may have received an email from Jora at the Alabama Department of Public Health. If you've not opened that already, will you please delete it and have your IT staff delete it from your servers? Then I'll get a confirmation back from Ms. Smith, an email or something in writing that says, hey, I was contacted by the Department of Public Health. I received an email, but I never viewed it. Or if there may be situations where someone actually opened it already, and they may say, yeah, I've opened it, but I haven't had a chance to read it in its entirety. What we might say is, okay, well, can you make sure that you delete it, confirm that it's deleted, that type of thing. Find out if they're working for a covered entity, because that makes a difference when we're doing the risk assessment. So there are things that we can do to mitigate these types of issues, whether it be sending something to the wrong email or even faxing something to the wrong fax number, if we know ahead of time. But if you wait, that just makes the situation that much worse. So that is something that I definitely wanted to make sure that we pointed out, because in each allegation of a breach here at the department, I do perform a risk assessment. And depending on how you answer the questions in the risk assessment, it lets you know whether or not you actually need to perform breach notification. So, so that is very important. Now for the next skit.
Good morning, ladies.
Good morning.
How was your weekend?
Oh, it was awesome.
It was great.
It's good.
We look so fabulous today.
You know what that means.
Selfies.
Here, I'll take it.
Now, I'll just go ahead and post it to my Facebook and Instagram.
Oh, please tag us.
Tag me.
Will do.
Okay, I love that skit. One thing that that is at issue is that I want to make sure that our employees are aware of, and you probably already are, but our you can say younger or less seasoned staff are obsessed with taking pictures and social media. And then, there are some people who've been here for a while and are still obsessed with social media. But we have to be careful with this whole selfie thing and ussies and the selfie sticks and the whole 9 yards. If you'll notice in that skit, there was a patient, Carol, in the background. And also you could see that there was a health department sign behind her and another poster with health information. So when they took that picture and started posting it on social media, that's going to be a breach because it's our department staff. They belong to a covered entity, and they're posting a full face image of that particular patient. So remember, PHI includes a full face image of a particular patient. So all of that's a problem. It is also an issue as it relates to the confidentiality of that patient. What if she was coming in today and didn't want people to know that she was at the health department? So that's an issue. Social media can be certainly a benefit to the department. It helps us get information out quickly. It helps us with education. But we have to watch how we carry ourselves on social media. One example is be careful not to give medical advice on Facebook. Even if you are a nurse or a nurse practitioner or a social worker, even if you are somebody who's not an actual healthcare provider, just because you work for the Department of Public Health, people will assume that you have some expertise as it relates to the medical field just because you work for the Department of Public Health. So be careful not to be giving medical advice on Facebook or on social media. And also, this happens very innocently, but, someone may come into the health department that I went to high school with, and I may just send them on their status on Facebook, "Oh, it was great to see you today at work." Well, if people know that I work for the health department, I don't have to say I work for the Montgomery County Health Department. If all of my friends on Facebook know that that's where I work, and I'm saying, "Hey, it was good to see you at work today, Joe Smith," then now all of those people know that Joe Smith was at the health department today. So be very careful and conscious of how you handle yourself on social media. Now let's look at another skit.
Well, this is the worst part of my day. Not only does a nurse practitioner have to see patients, we have to document everything that we do. Okay, Miss Johnson. Exam, I did that. Check. HIV pre-testing. Counseling, I didn't do that, but I probably should have. If I check it, we'll get more money. And they're always talking about needing more money around here. Okay. HIV pre-test counseling, check.
Okay, so newsflash, that is extremely illegal. You cannot do that. You cannot document or get reimbursed for a service that you did not provide. That is absolutely illegal. It can be considered a violation of the False Claims Act to document or claim that you did a service that you did not do. And we can't receive payment if we did not actually provide that service. So it's very important that you not do that. Please know that you could have a felony conviction for doing that. You could serve time in prison. You could end up having to reimburse the federal government for the amount of money that they paid when you billed for a service that you didn't do. You could also end up on what's called the OIG exclusions list. And let me explain that. The Office of Inspector General has an excluded, suspended, and debarment list. These are for individuals that they are telling the healthcare industry, you cannot pay these individuals with federal funds. And it's generally because they've done things like you just saw in the skit. They've done upcoding, other types of fraud with federal money is what got these individuals on the list. It could also be something as innocent as not paying back their student loans, which I think is really interesting for physicians that aren't doing that. They could end up being placed on that list. And the issue is if you receive federal money, like the department does, then we can't use that federal money to pay people who are on the excluded or suspension or debarment list. And by doing what she just did in the skit, they could end up getting you placed on the list, which means that you obviously can't work for the Department of Public Health because we can't pay you. And just some more information about that exclusions list, we do run checks of we get lists from personnel, we get lists for all the people that we do contracts with, both in human resources and in the Office of General Counsel. We also work with finance for the people that we actually cut checks to make sure that we're not actually paying individuals or entities that are on that exclusions list. So that is very, very important. I also want to talk with you a little bit about the anti-kickback statute, and I'm actually going to have to read this in lawyerese first, and then I'll explain it to you in English. But the anti-kickback statute forbids any knowing and willful conduct involving the solicitation, receipt, offer, or payment of any kind in return to referring an individual or recommending or arranging the purchase, lease, or ordering of an item or a service that may be wholly or partially paid for under a federal health care program. So what that means in plain English is if you work for a program that has federal funds, then you can't then go and say, hey, vendor, if you give me, maybe $20 per referral, I'll make sure that I buy, well, if you're going to another, provider in terms of referrals, if you give me so many referrals, if I give you so many referrals, you'll give me $20. Or if I buy these items from you, then you'll give me money back or a gift card or something like that. That is absolutely illegal, and I think that the next slide is going to help us with an understanding of that.
Thank you so much for showing me this catalog. I really like your products. I just need to run it by my supervisor.
So y'all considered any other companies?
Well, yes, whoever gives us the best deal.
Well, I don't know about that, but do you like to go out to eat?
Of course, who doesn't?
Well, if you give us the business, maybe then I can give you some, gift cards to some nice restaurants. Would that help sweeten the deal?
Okay, so I know that there are going to be people gunning for me, keying my card, not excited about the fact that I'm saying that you cannot get these types of gifts from vendors or from other people who are seeking referrals, but you cannot. This should not be new news. Some of this information is listed in the professional conduct policy already that I'm sure everybody has already thoroughly reviewed, but you cannot receive money or gifts in exchange for you buying certain items from particular vendors. Now, let me also say, if a group is coming in and they're doing a training and they're serving lunch, then obviously, we do that from time to time. That is an exception. That's different from actually receiving a gift card, which is perceived as cash. I know there have been times where people have said, hey, but it's just, a $5 gift card. It seems so nominal, but a gift card is it is money. So you cannot receive those types of things in exchange. I want to talk with you a little bit about the role of the privacy officer. First of all covered entities, like the department, has to have a designated privacy officer. They are responsible for assessing the department's privacy issues, for implementing policies and procedures. We also develop and implement the training, resolve complaints related to HIPAA, and keep the required documentation administratively for the 6 years that we are required to make sure that we have that in place. Each covered entity, like the department, is also required to have a security officer. The responsibilities of the security officer include implementing the security policies and procedures, assisting with implementing and developing the HIPAA training, overseeing security of EPHI, identifying and evaluating threats to the confidentiality and integrity of EPHI, responding to actual or suspected breaches in the confidentiality or integrity of EPHI, And so you should review the ADPH HIPAA Security Manual for more details about the safeguards that the department has implemented to protect EPHI. That resource is available to you in the document library. Also, contact the HIPAA security officer with any questions that you have regarding information security or EPHI. I want to talk with you a little bit about exactly what EPHI is. EPHI is information that is electronically created or electronically received at rest or maintained in storage devices such as computer hard drives or disks, or is EPHI that is in transit via the internet or dial-up lines. Now, in order to understand exactly what EPHI is, you must also understand what it is not. PHI it is PHI that was not in electronic form before transmission. So if you're talking about a person-to-person telephone call, that's not EPHI. Information that you copied through a copy machine, it was on paper first, so that's not EPHI. Also, paper-to-paper fax machines. So I take a piece of paper, I fax it, it goes through, it comes out as paper on the other end. That is not considered PHI, in addition to most voicemail messages. None of those are considered to be PHI. It's important to know what de-identified information is. De-identified information is when certain factors are taken out of someone's record where you can't possibly figure out who that individual is. So all those things that we listed before, name, address, all that stuff, date of birth, date of service, all of those things are taken out. Usually the only thing that is allowed to be left would be a zip code for it to be considered de-identified. I won't go into too much detail for that with you all, just for this kind of global HIPAA training. I know I've gotten pretty specific with the individuals who do the HIPAA log and who make disclosures. They have a good understanding of what de-identified information is, but I wanted to make sure that you all are aware that once a record is de-identified and all those factors have been removed, it is not considered to be EPHI. And the HIPAA security rule establishes the standards for safeguarding EPHI only. The privacy rule will dictate all of the rest of it. So let's talk about some of the major security risks. Malicious computer software, like viruses, obviously that's a security risk. Unauthorized use of system usernames or passwords, and weak or ineffective passwords are all considered major risks. Malicious computer software can damage and disrupt the departmental computer systems by affecting the confidentiality, availability, and integrity of EPHI. It gets into your computer from infected email attachments, or websites, or disks, or CDs that already contain malicious software. So how can you protect yourself from malicious software? Number one, don't open an email attachment that looks suspicious. We've all seen these. It comes from somebody that we think we know. A lot of the things are misspelled. You can look at the link and you can just tell, if I were in my private account, I would not open this. Well, if it was in your private account and you wouldn't open it, then you need to bring that to the attention of your IT staff here if you get an email on your work email that looks suspicious. You also want to report any suspicious emails to the security officer or the IT staff person that is assigned to your office. And also comply with instructions to update virus protection software. Never copy or download software without permission from your supervisor. And do not disable or tamper with virus protection software. It's very important that we allow those updates to come through. And make sure that any computer or laptop that you use has up-to-date virus protection. Now, your username and password are your electronic signature. The department is able to use that login information to audit your activity and see where you've been. So you must make sure that you keep your username and your password secure and confidential to protect the integrity of EPHI. You can never, ever share your username and password with other people. Now, I understand that for many of us, remembering all these passwords is extremely difficult, but the department does require strong password protection. Now, and if you think about it, it really is the right thing to do. A lot of us have passwords that we have to use for our online banking. If I wanted to go online right now to order a pair of shoes or a dress, they're going to require me to have a password, and that password is going to have to be a certain strength. So within our department, we must require strong password protection as well. The Alabama Department of Public Health, I say this all the time, is one of the largest creators, maintainers, and users of PHI in the state. Therefore, we must be able to protect our patient information. So with that, let's go to this next skit and talk about what not to do.
I swear, that new compliance officer sits upstairs in her big old office thinking of ways to frustrate me. Every time I turn on this computer, it's time to change my password.
Bill, what is going on? I mean,
Time to change the password again.
Again?
Again.
I mean, what do they want from us? I'm already using 16 or 32 characters. I mean, hashtag and numbers and alphabet. Do they want a pictogram that comes along with that?
I don't know. How do you come up with your password?
I normally use my son's name and his year of birth.
I got a son. What's your son's name?
Neil.
What year was Neil born?
1993.
Okay, so I think that's hilarious. I mean, obviously, he's given him his password right there. So you want to be mindful not to tell people what your password is, the tricks that you use to remember your password. Let that be very personal and confidential, and let that be just for you. It's interesting what he says about it's 16 or 32 characters. It is not. There are no hashtags related to your passwords, but it does. What we do use is a standard in the healthcare industry for what your password should be. So let's be careful that even in our normal casual conversation that we're not telling people what the passwords are. And you'll notice, because I know all of you all looked at the awareness HIPAA training, that we decided not to do the issue with putting passwords on your monitors. And that is because I want to congratulate you all as a whole. I have done HIPAA privacy and security walkthroughs in all floors of the RSA Tower. By the time this video goes out, it would have been literally every area. I would have gone to counties in every area. And you all are doing a great job of not putting your passwords on or near your monitor or your computer. As I look at different workstations, I'm not able to find out what your passwords are to your computer. So as you can see, we've moved on from that. We only want to provide you refresher training on what is actually pertinent at this time. And again, congratulations for being in compliance with those password protection requirements. So let's go to the next skit.
Can you believe this?
I thought we were going to talk about passwords again, Bill.
No. They want data information on our clients.
Is that a lot?
Well, there's over 3,000 patients in the database.
Better you than me, I can tell you that.
I know what. I'll just put it on my jump drive.
Now, Bill, you know we're supposed to use an encrypted jump drive. You just can't use a regular jump drive.
You're paranoid. I'll just put it on the jump drive and walk it up the street.
So, like, no, you absolutely cannot do that. If you want to, like, give me a heart attack on a Tuesday, like, let me know that there's a jump drive missing with patient information on it. That's going to be a major problem. I'm not saying that you can't put patient information on a jump drive. I do understand, or I'm at least technologically savvy enough to understand that people use jump drives or flash drives. You're able to put a lot of information on it, and you need it for work. What I'm saying is that if you're going to do that and there's going to be PHI on it, then it has to be encrypted. It has to be encrypted. It can't be a situation where I'm just walking down the street or I'm just walking over to this next office. All of those are situations where that flash drive can get lost, misplaced, stolen, whatever. It has to be encrypted. There are no exceptions to that. If you have questions about where to buy encrypted flash drives, contact my office. I'm happy to share that information with you. I also want to talk with you pretty quickly about the mobile devices. As we talked before in our awareness training, as it relates to our cell phones, many of you remember back in 2013, we went to a thing of personal cell phone and work cell phones. One thing I want to say about the cell phones is that doesn't mean that you can't use your personal cell phone or your iPhone to go to the ADPH website to go into iNotes. Like, I understand that people are using their iPhones to do that, and that's fine. What we did though is to make sure that you're not able to download the application so that it's always available on your cell phone without having to enter a password. So I just want to be really clear on that. I do know that people can use their business cell phone to make calls back to the office, and you can use your personal cell phone, obviously, to call the office. Oh, I said that wrong, I'm sorry. That people can use their work cell phone to make a personal cell phone call if you're okay, if your supervisor is okay with that. And you can use your personal cell phone to call the office. All of that's fine. But what we're saying is you can't download anything related to work on your personal cell phone. You can only use your personal cell phone as the computer that it basically is by logging into ADPH and going to iNotes. And one more note about iNotes, there is an icon there when you go into iNotes for the first time that allows you to save your password. Do not, NOT all caps and in red like blinking letters, do not save your password to your iPhone or your personal phone. You cannot do that. We can see who is doing that. So we're knocking everybody out who already has done that. And moving forward, now that we're making this announcement to everybody, please know not to choose that option. It's just dangerous because if you lose your personal cell phone and your iNotes password is saved in your phone, then people can go through Lotus Notes. And generally for most of our employees, there's plenty of PHI within our Lotus Notes accounts. So I wanted to make that statement. Also, as it relates to laptops, as many of you all know, there was a huge encryption effort. Again, I want to thank Regina Patterson and David Newman, everybody in IT for helping with this to make sure that we get all of our laptops encrypted. We talked about flash drives, and the last thing I wanted to talk with you all about in this slide has to do with the Health and Human Services recommendations. Many of you saw the 2013 awareness training where the Department of Health and Human Services did a whole maybe 3 or 4 minute skit about how to use mobile devices, how to use them in Starbucks, at a coffee shop, you know, where to place them, make sure that they're in the trunk and out of place, make sure that you keep those devices on you. I'd like to, in the interest of time, I have not included that video in this training because I know that a lot of you all have paid attention to that video before, but I did want to make you aware that on our internal website, which is the adph.org/compliance education, we do have that video available for you to view. So feel free to go and refresh your mind as it relates to those mobile devices. This slide relates to semantic email encryption. This just shows you what the person gets when you send them an email that has been encrypted. So this just for sake of example, if I work at Medicaid and you send me an email that has PHI in it for the first time, this is what I'll receive. It'll let me know that it's from you. It'll have this little message with it. And what I would do then is just to go in and create my own password. We don't give them the password. They create their own password. They enter that password twice. And then from now on, when they receive communications from you, all they do is just type in that password and they're able to open up that document. If anybody has any additional questions about email encryption, we did have a video on that. I believe it was back in June. And that video is at that website that I mentioned earlier, which was the adph.org/compliance education. All right, next I wanted to talk with you all about the CHR3. So one of the things that I wanted to mention has to do with texting. I know that a number of individuals in our programs wanted to be able to send text message appointment reminders. Now, thanks to Joe Lee and Leslie Hay, they have helped us to make sure that our encryption software was not causing errors with our text messages. And let me explain why that would even be an issue. When we talk about texting appointment reminders, it looks to the patient like it's a text message. But in fact, we're not picking up our cell phones, personal or work phones, to actually text them. What we're doing is, and I know a lot of our counties and people who are working with this have a list that our office provided them, and it has all of the email addresses for all of the major phone companies. So for instance, I use AT&T. So my address would be 334-555-5555 at text.message.att, whatever it is. That's just an example off the top of my head, but that would be the address that in Lotus Notes, when you go to send an email, you would type that number in with the rest of that email address and you'll send it. And the reason that we want to do it that way is now, since it's in Lotus Notes, we have a record of exactly where you sent it and exactly what you said. And that's important both from a compliance standpoint, but also from your standpoint, because now you have something that you can print out and put in the medical record and that shows that you actually did send it. So the patient can't say, oh, I didn't realize that I had an appointment. It's like, well, no, I got this, and it shows that this went through and there was no errors with that. So that's that's some information that I wanted to give you as it related to text messaging. And obviously, because we're doing that through Lotus Notes, what was initially happening was that since it had information about a patient and it was talking about appointment reminders, the encryption software was picking that message up. So when the patient got it, it didn't just give them information about their appointment. It also gave them all of the normal language that was typical in our semantic software encryption. So that information has been addressed, and that situation has been addressed, and we're very, very grateful for that. As it relates to patient designations in the CHR3, if you go back and look at that form in the document library, you will see where there is an opportunity now for patients to designate an individual who we can talk with about their health care. And there are certain criteria that they have to fill out in order for us to be able to do that. And that leads me to having a brief conversation with you about the difference between the CHR3 and the CHR6. Just to be very straight with you, the CHR3 is meant for, the best example that I can give is you may have a 15-year-old. They are wanting to come for family planning. The mom is totally involved in their health care. There aren't any secrets between the two. Maybe the 15-year-old is on their way to soccer practice. They have an appointment at 4 and they need to get their appointment changed to 4:30. Where in a typical situation, if the 15-year-old has been coming and signing for herself, if mom calls and says, hey, we need to change her appointment from 4 to 4:30, our staff wouldn't even acknowledge that patient had a 4 o'clock appointment. I mean, that the patient had a 4 o'clock appointment, because we wouldn't tell the mother about that because the kid is 15 and they're signing for themselves. But if they use the CHR3 and they designate the mother as somebody who we can talk with, we can do those types of things. Also, it could be used for the same 15-year-old comes in and she talks to the nurse or the nurse practitioner about her condition, and the mom has some questions. The mom can then call and ask some additional follow-up questions. We're allowed to communicate with that mom on a very general level. Now, the difference between the CHR3 and the CHR6 is a CHR6 allows us to actually provide a record. The CHR3 doesn't do that. That's more of a casual conversation or rescheduling of appointments. If somebody wants actual copies of the medical record, they still have to go to the CHR6 and fill that out. So if that same 15-year-old wants her mom to be able to pick up a full copy of her medical record, she's going to need to complete a CHR6 that gives her mother authority to get the copies of that medical record. So I want to be really clear on that. And if you have any questions about that, please call me. I also want to make sure that people are aware of the HIPAA log. It's been up and running almost a year. We're getting close to reaching the 1-year anniversary for it. There has been specific training for eHIPAA log users on how to use the eHIPAA log. But the reason that I bring that up in this training is from time to time, we'll still hear about people going or just saying, hey, I didn't realize that we had the eHIPAA log. I didn't realize that we needed to be documenting these disclosures. If you feel that you are a person that needs to have access to the eHIPAA log because you're disclosing information from a patient record, or if you feel that there's someone in your office that needs access, please contact me or have that person contact me. I can talk you through it and we can decide together whether or not those are things that need to be placed in the eHIPAA log and if you need to have access to it. We can very, very easily provide you access to the eHIPAA log as well as the training. And so as it relates to breach notification, I know pretty much everybody knows the way to submit an ARIA report for breaches is to go to the adph.org website. You'll see in the top right-hand corner, there's an area for login. So you will go ahead, log in, and once you log in, you'll see a listing of the different forms. About a little over midway down, you'll see the ARIA, the Automated Report of Incidents and Accidents. One of the things that I wanted to note for you all that's actually changed a bit with that process is once you click that link for ARIA, you're going to notice that at the very top of the page, it talks about information for home health. And then you'll see where it says privacy and security incidents. That is how you report a breach now. It used to be that if you just went in the general ARIA, there was a drop-down box, and along with automobile accidents and slip and fall issues and medical practice issues, all of those things, the breaches were within that drop-down. Now they're at the top of the page, and if you click that, it'll take you to a form, and that will allow me to receive the email directly about the fact that you're reporting a breach. So that's really important to make sure that you are clicking that link at the top of that page for privacy and security incidents. So it looks like it might be time for another skit.
Well, Miss Smith, I think we've gotten everything. As soon as we get all your documents in order, I'll be giving you a call.
Thank you. Tax time is so stressful, so I know I can use my refund ASAP.
Thank you.
Oh, I know what you mean. We can all use a little extra cash.
Don't I know it?
I noticed you were wearing an Alabama Department of Public Health name badge. I bet you have access to a lot of patient information.
Well, yes, I've been working there for a few years.
Yeah. Listen, if you ever want to earn a little extra cash, I can put you in touch with the right people.
Really?
All you have to do is use some of that patient information, give us a list of patients, birth dates, social security numbers. All you have to do is provide the information, and they do all the rest. It's really easy, and here's the best part. Nobody gets hurt, but we all get paid. Here, let me tell you. Here's my card. My cell phone's on the back. You give me a call.
Okay, so do not do that. That is going to get you in a world of trouble. I don't know if you paid attention to the sign at the beginning, but it's called sham tax services. That's going to do nothing but get you in trouble. It's going to be a problem for you on every level, state, federal, ADPH, everything. You cannot do that. We have had employees who have gotten in trouble for that in the past, and I'm going to talk about that a little bit more in a minute. But I want to make you aware about the civil monetary penalties associated with breaching patient information. So we've gone over this slide before, but just as a reminder, if an entity did not know, they weren't aware that the breaches were taking place, it could be anywhere between $100,000 to $50,000 for each violation. And if the particular entity just willfully neglected the issue and when they found out about it, didn't correct it, that could be a $50,000 fine per violation. And then over in the right-hand column, you'll see that each of those is $1.5 million, and that is for violations of identical issues within the same calendar year. And the reason that it's that way is what the feds want us to do is if we see an issue where there's a breach taking place, a procedure is out of order, there's a policy that needs to be drafted and provided to departmental staff, and we don't do that, and it continues to happen in the same calendar year, that's when you get those real steep fines, because they want you to address the issue and stop it from happening. Now, it's very important that you realize that there are criminal penalties associated with it. The American Recovery and Reinvestment Act of 2009, also known as the ARA, expanded HIPAA by providing criminal penalties for employees or others who wrongfully disclose individually identifiable health information. And speaking of those individuals, it brings us to this slide. And just so that you can see it a little bit better, some of you all will remember a few years back we had Latice Phillips, and she was actually sentenced to 94 months in federal prison with a restitution of $567,634. Or maybe it's $31, I'm sorry. Maybe I didn't read that right. $567,631. And what did she do? Well, she actually pled guilty to 1 count of wire fraud and 1 count of aggravated identity theft. And the reason that that's important is because I want you to understand, just like in that skit, what they're saying is, hey, all we want you to do is get us lists of names, of social security numbers, of dates of birth. We're not asking you to file the false tax returns. We're not even asking you to go get the money out of the bank when the money comes in. All we want you to do is just give us the list, and we'll do all the rest of it. And you heard her saying the skit, nobody gets hurt. Well, let me tell you, people do get hurt, and you do hear from those victims at the sentencing for these individuals, and those judges the federal judges take it extremely seriously about how you're affecting these other people's lives. So we want to make sure that we understand that just by providing somebody information and it seems harmless, it can be extremely harmful to the individuals on the other end. Now we have another person, Tamika Floyd. Some of you all may remember some discussions about her last year and again this year. She was sentenced this year, and she was sentenced to 87 months in federal prison and 3 years of supervised probation. Now I want to make sure that y'all understand that you are reading this slide right, where it says that she has to pay a restitution of $3,092,885. So yes, I did say greater than $3 million worth of restitution after she comes out of prison, already has a felony on her record. So what Ms. Floyd actually did is the same thing that Ms. Phillips did. They provided all of this information to a group of people and those groups of people went and participated in the identity theft further by filing the false tax returns. Ms. Floyd didn't actually file anything. She just provided the information. But she gets, as a co-conspirator, the same things that the other people received. In her situation, it was even that much more damaging because they were looking at teenagers. So when she was getting the information, she was trying to get people who were in their late teens. The federal judge, I can tell you, found that that much more disgusting, that for individuals who were trying to do right, graduating high school, either working, going on to college, trying to establish themselves in life, before they can even begin to establish themselves, their credit is already messed up. And one thing to think about too is now when you have those types of issues with identity theft, you can't, for a number of people, you can't file electronically anymore. You have to have letters and you have to file paper records. And to this group of younger people, that's extremely devastating when they're used to being able to do everything electronically. So that represented a major problem. So as you can see, both of those individuals were caught. I can tell you that Columbus, Georgia is a big hub for identity theft. The feds are paying particular attention not only to Columbus, but all the surrounding areas. And in general, they're stepping up their enforcement. And what they're doing is specifically going after the people who are providing the information. They decided it doesn't do as much good to try to get people on the back end after they've already collected the money. It's better to try to get the people who are actually providing the list. So that's what they're doing, and that's exactly how these people got caught. Now, I've told you before, I have a sister who's a prosecutor. I hear her talk about work stuff all the time. you can almost do nothing in secret when you have co-conspirators. As soon as one person gets caught, they start singing, they start telling on everybody else. So just because you did something maybe 2 years ago by providing names, if somebody gets caught on down the line, the feds have ways of going through emails, phone records, search warrants, all those things, and it can eventually get back to you. So my best advice is not to participate in this at all. I wanted to, in closing, I wanted to talk with you all about this compliance education, what we're calling a one-stop shop. So I mentioned this site before, and it's the adph.org/compliance education. It's going to have everything that you need there. So if you need training on the HIPAA log or any of the business associate training. And don't worry, for everybody who's asking themselves, what is that? If you don't already know what that is, then that training was not for you. We've already contacted the people who needed that training. Our general training, like this 2015 HIPAA training, HIPAA and compliance training, any of the other trainings related to the Office of Compliance and Ethics will be there at that website. Also, I wanted to make a statement about the monthly videos. Before, as we were doing the monthly videos, you'll remember there was an email encryption video, there was a game, there was a video about HIPAA happens. None of those things had an acknowledgement form. From now, I know at the time that this video comes out, but from September of 2015 on, we will have those videos in LCMS, and you will need to submit an acknowledgement form after you watch those videos. I was kind of hoping that people would kind of be on the honor system and just watch it without having to do the acknowledgement forms. But what I'm finding is that everybody's not as hyped up about HIPAA as I am. So in order to make sure that you actually watch the video, you will have to complete that acknowledgement form. So I wanted to make you aware of that. Also, as a matter of just general housekeeping, I just wanted to say to you all, in terms of the spelling of HIPAA, just remember that it stands for the Health Insurance Portability and Accountability Act. So that's HIPAA. It is not HIPPA. And so as going around doing the walkthroughs, like there's a lot of people who really do take it seriously, and they have, signs that say due to HIPAA requirements and that kind of stuff. And I really appreciate you doing that. It would just be so much better if HIPAA was actually spelled correctly. So remember, it's 1 P and 2 A's. And I think that people initially got confused because all throughout the healthcare industry, we were talking about HIPAA, because that was, a word that sounded like HIPAA. And there are obviously 2 P's in hippopotamus. It is not that. Divorce that whole HIPAA thing, hippopotamus thing, like you never heard it. It is the opposite of that. So it's HIPAA, 1 P and 2 A's. And finally, I wanted to just say to you all that throughout this HIPAA training and even the monthly training exercises that are provided to you, we're not trying to make you HIPAA experts. I could probably talk for a whole day if anybody would ever let me, and I know that they wouldn't. But I could probably talk for a really long time about things that people might want to know or consider about HIPAA. Instead, what I'd like to do with you all, like I said, I know your time is valuable, is to give you enough information so that you're able to do your job and that you're able to recognize situations that you may need to talk with me about. So as you're going through your day and you're saying, hey, doesn't that look like a violation of the minimum necessary rule? Didn't Samaria say something about that? And then you give me a call, that kind of thing. So I'm not trying to make you a HIPAA expert, no more than I can be an expert at your discipline. However, I do want you to have enough information that you know when it's time to give me a call. I try to be extremely responsive. And speaking of being responsive, this is my contact information. It's got the address to mail us things, phone number, my email address. Also, as you'll see there, is the adph.org/compliance. The compliance education site that we were talking about is an internal site, but this compliance site, the general one, is there for anybody, even people outside of the department, to see. It also has like a copy of our notice of privacy practices and other educational material there. So please feel free to go there. Also, right at this moment, we have an acting security officer who's Leslie Hay. He works in information technology. I do understand that we are looking to hire an official security officer, but for now, the acting security officer is Leslie Hay. And if you have any questions at all about HIPAA privacy and security, just always feel free to call the Office of Compliance and Ethics with any questions that you have. So I want you all to remember, as we conclude, make sure that you read the policies. They should be to the right of your screen as this video plays. Again, those policies are the 2015 HIPAA policy, the 2015 compliance policy, the professional conduct policy, and the remote access policy. Review those things and do your electronic acknowledgement so that you can get credit for this course. Again, any questions that you have or any concerns that you have, please feel free to call me, and I thank you for your time.